Welcome everyone to the May edition of the Hillwalloch Power Hour. I'm your moderator, John Katz, and we have a great panel for you today. We have George Greatrex, Caroline Record, who are going to be speaking about electric vehicle charging stations, Michael Karpoff, who's going to be speaking about capital improvements, and Ken Sauter, who's going to be speaking about loans for community associations. Let's start off with a little legal disclaimer. Although we are all attorneys here, and in some cases we may be your attorneys, we are not acting as your attorneys today. The advice that we are giving is going to be general in nature. So if you do have a question regarding your specific association, you can feel free to contact your community association attorney, or you can feel free to contact any of us on the panel. A couple other things before we get started. This webinar is being recorded to be used later. We will send out the webinar afterwards, a PowerPoint of the webinar, as well as the YouTube video of the webinar in case you would like to review it again or share it with any of your friends and colleagues. If you do have questions during the webinar, please use the Q&A function on the bottom of the screen. The chat should be disabled. We'll check on that as well. So please use the Q&A function. We may get to the questions as they come up, or we may get to the questions after each presenter, but we hope to have some time at the end of the presentation to ask your questions about anything the presenters may have, or if you just have any general questions that we may be able to answer for you today. This webinar has been approved by KMICB for 1 hour of continuing education credit. However, you must stay on for the whole program to receive credit. We do review the printout after the webinar is over, and your certificates will be emailed within 7 to 10 days after the webinar. And like I mentioned before, we will be providing a copy of the slides as well as a recording of the webinar within 7 to 10 days after this webinar airs. So please advance to the next slide. As I mentioned, we have 3 topics on the agenda today. The first is electric vehicle charging stations, loans to community associations, and capital improvements. And with that, I'm going to turn it over first to George Greatrex to start with electric vehicle charging stations. George.
Thanks, John. Hello, everybody. Happy lunchtime, and welcome again to our Hillwalloch Power Hour. So by show of hands, how many of you have had residents come to you, the board or the manager, requesting permission to install a charging station for their electric vehicles? I know I can't see you, so I don't know how many people are raising their hand, but I got to believe there are some, including some of us right here on the panel. I have to believe as well, and it makes sense, right, that these days with the price of gas and all of the new electric vehicles that are being marketed out there, that there are going to be more and more of these types of applications and requests for information of you as we go forward. You know, it's been probably several years now that people have been starting to buy and drive electric vehicles. And so it's likely that some of you have, in fact, had some of your residents come to you and say, how do I do this? How can I charge my electric vehicle right here at home in my common interest community? Just like, you know, it turned out with solar panels and also with satellite dishes, there was a time when associations were just able to say, no, we're not going to let you do that. We're not going to allow you to do that. However, just like those other 2 issues that or examples that I gave you, the legislature stepped in and in fact has been trying to step in this area for a couple of years now. There was a bill that was first introduced in about 3 sessions ago in the legislature in Trenton back in 2017 that would have prohibited associations from either prohibiting or unreasonably restricting the installation of charging stations. They were introduced by 2 senators who are known for promoting the green initiatives, one being Senator Bob Smith and the other being Senator Gordon Johnson. And it turns out that the bill that was introduced in the last legislative session that was ultimately passed into law, which is what I'm going to talk about today, was really, it started out as a bare bones prohibition on associations preventing these installations. I'm proud to say that the CAI's Legislative Action Committee, of which I was a part and still am, we took our questions and our concerns to those sponsors, and as a result, after a lot of negotiating, we were able to get a lot of our concerns and issues put into the bill, which was eventually signed into law by Governor Murphy, as it says there, on October 19th of 2020. The bill itself was numbered A 3367, and the Senate version was 1951. And if you want to write this down, where you can actually find it, the actual law is at NJSA 45:22A-48.4. And what that is an amendment to the Planned Real Estate Development Full Disclosure Act that you all know applies to all of our homeowner associations here in New Jersey. So that bill, fortunately, with the efforts of the LAC, and in particular Matt Earl, who is currently the chair of our LAC, we were able to get a lot of our concerns addressed. And I'm going to read some of these provisions to you so that you know what power you as an association have to reasonably regulate the installation of electric vehicle charging stations. You can't say no, but you can reasonably regulate them. And some of the things that through our efforts on the LAC, we now have as part of the law, and I'll read them to you. One is that the association can impose reasonable architectural standards for the charging stations. The association can require that the owner of the unit engage a licensed electrician to perform the charging station installation. We can require that the association or that the owner has to obtain at least $100,000 in insurance, homeowners liability insurance. And in fact, it may need to be more depending on what the governing documents say. The law now says that the owner has to pay the entire electricity charge for whatever they use for their vehicle. And I'm going to talk about that issue in a second with the new law as well. It also says that the owner has to pay for all of the review charges incurred by the association, such as engineering fees, electrician fees, and legal fees. The charging station application can be denied if it poses a life safety risk. Owners are responsible for all damages caused by the charging station and all installation costs. The owner has to advise prospective purchasers of the owner's unit of the charging station and the responsibilities that are pertinent to that. Further, the owner must indemnify and hold the association and other owners harmless for any claims for bodily injury and property damage that are related to the charging station. And also boards, association boards in their own discretion have the authority under this law to license a common area, which are non-assigned parking spaces, to an owner to install the charging station, or to create new parking spaces for the purposes of installation of charging stations, and in fact to install their own charging stations as common property to be used for common use by anyone in the association that needs it. And then finally, and fortunately, we were able to have taken out of the bill all the punitive provisions that were included in it, which had a lot to do with fines and things like that against associations who violated this. So what we're talking about here, folks, is for instance, if you live in a condominium or you work in a condominium association, and if you have assigned parking or designated parking spots, we as an association cannot say no to an application of a unit owner who wants to install their charging station right there on their common property. Also, if you're, for instance, if you're in a townhouse, the unit owner can install this charging station inside of the garage. But again, they have to submit applications, and the association by law has the right to address those applications in the same way that any other architectural application is presented. And then finally, I'm going to talk to you quickly about another law that was passed just this past January that says that the local electric utility can only charge the residential rate to the association and to the unit owner for the use of those charging stations. They can't charge the commercial rate, which obviously is higher. So how do you put all of this into play? Well, I'm going to turn it over to Caroline, and Caroline is going to tell you what you as associations, with the help of your legal counsel, can do to put these procedures and license agreements into place. So take it away, Caroline.
Thank you, George, and good afternoon, everybody. So as George has just very quickly gone through what the actual law says, now it becomes the board or the association's responsibility to evaluate these applications. And how do we do that, or how is it suggested we do that, and what you can and cannot do. So I don't want to repeat everything that George is saying, but first and foremost, and the one thing, two things to remember. Number one is that an owner is entitled to this electric vehicle charging station only with regard to their designated parking space. So as George said, if they have a garage, if they have a driveway, or if they have an assigned parking spot under the current law, they are entitled, that owner, if they request it and they follow all of the requirements, to have this designated parking space and the electric vehicle charging station. If there is no assigned parking or designated parking in the community, and someone asks for one of these electric vehicle charging stations, the board is under no obligation to provide one. It can do so pursuant to any rules that it establishes, but it is not obligated to do so. And finally, there have been a lot of questions about whether or not the association itself has to provide electric vehicle charging stations common for use by anyone in the community. And right now, that is not an obligation. It is certainly something that we're seeing a lot of questions about, and because this is going to happen and people are going to get more electric vehicles, a lot of boards are considering it, and it's not an inexpensive thing to do. But anyway, when this first came out, there were a lot of questions or comments that the governing documents had to be amended to allow this, and that's not the case. The process put in place by the board can be done by a resolution, and it can be a resolution dedicated just to electric vehicle charging stations, or it can be a more generic resolution for exterior modifications with certain specifications for electric vehicle charging stations, and that's up to the board. So while the board may be developing a more specific resolution, you can utilize a resolution or a policy that is already in place for exterior modifications in the interim, in the event that you do get an application. Once you receive an application, the answer can't be, well, we're working on it and we'll get back to you, because under the law, the association must deny the application in writing within 60 days of its receipt, or it's deemed approved. So you're going to be under very tight time constraints when you receive one of these applications. I have already had more than one question or frantic phone call that someone has already installed an electric vehicle charging station without permission. And what do we do? And I asked, do you have a policy in place? No, we don't. I said, well, they are entitled to a certain extent under the law to have one of these things, but you're also entitled to have certain information and certain documentation. So you need to work with the person. And certainly if that happens, talk to your attorney. But anyway, as I said, you should think about developing a specific policy, or at least specifications with regard to one of these installations. Don't do it yourselves. Hire a professional consultant to develop these specifications, because in the few webinars that I've attended with regard to this issue, the specifications and all of the information is very, very technical. It's actually very interesting, but it's very, very technical. Keep in mind that while the association can impose reasonable restrictions, requirements with regard to the electric vehicle charging stations, these restrictions cannot significantly increase the cost of the installation or decrease the efficiency or performance. The board is obligated to approve an application if it complies with whatever architectural standards have been developed. If the owner has agreed to engage a licensed electrician to install whatever electrical work needs to be done, agrees to have a licensed contractor install the actual electric vehicle charging station, obtains all the necessary permits from the municipality, produces the proof of insurance that George mentioned of at least $100,000 minimum, unless your documents require more for any type of exterior alteration. And the insurance has to protect the association and the other owners from any particular damage. Owner agrees to pay for all electrical use, as George mentioned. If the association, you don't know what you're looking at and you have to hire a consultant to review the application, if you don't develop your own specifications, the owner would be responsible to pay for that cost and any legal costs incurred. And most important is that the owner has to agree to indemnify and hold the association and the other owners harmless from claims for bodily injury and property damage. So if the owner satisfies all of the requirements set forth in the statute and hopefully included in your resolution, the association has to authorize the installation of the electric vehicle charging station. As George mentioned, if the owner is going to sell their home, one of the responsibilities and set forth in the statute is that they have to notify any subsequent purchaser of the existence of this electric vehicle charging station. The owner is also responsible for any damage that results from the installation of the electric vehicle charging station or the removal of the electric vehicle charging station. So these are all things that should be included in your policies. Once again, if you do receive an application, it has to be reviewed and or denied in under 60 days, or else it is deemed approved. So if it's over the summer and everybody's going on vacation or you're working on your policy, you know, under the law, they have a 60-day window. So you need to make sure that these types of applications are reviewed promptly. You know, maybe you don't meet over the summer as a board, you know, you got to make an effort to look at these things. If the electric vehicle installation would require any type of changes to the infrastructure of the building, let's say, or the community, there is, the law says that those who would be using it could share in the cost and could be required to share in the cost. And I haven't personally dealt with this yet, but this may come up in the context of a mid-rise or a high-rise, where maybe there's one electrical source and now you've got 12 electric vehicle charging stations adding to this load, for lack of a better term. So the application, remember the timeline, remember the requirements. You know, some associations are like, they're too ominous, we don't want to do this. That's the law. That's the law. You're entitled to ask for it, and you should be looking for a lot of these things. I saw a question in the chat is, can you say, well, we'd like you to install it in your garage or in your driveway? The comments that I've heard so far, and I do believe, and my panelists may disagree with me, is I think we can encourage people to install it in a particular location. I think most of the comments I've heard so far, the questions are that most boards would like to see it inside, because if it's outside and may have to be outside, and you've got wires running or things going either above or below pavement or whatnot, it's more of a disruption. But as long as it does not significantly increase the cost, I think there can be a preferred location. Although if that can't happen, that's something else. So that's it in a nutshell. I do encourage those of you who may be getting more applications or have some extra time on your hands. CAI is going to be presenting a full seminar. It's going to be in person in July, and George and I will be present along with Dan Rush of FWH and Lisa Reka, who is a community manager. And Dan will present the technical issues that, like I said, I think are very interesting. I didn't understand most of them, but it'll give you more information as far as the actual installation of the charging station.
It's actually June 21st, Caroline.
June 21st, I couldn't remember.
Yeah, and it's a CAI New Jersey sponsored event, so keep your eye.
And it's our Rossmore,
Right.
who's in Monroe Township.
Right.
So with that, John, I will turn it back to you.
So thank you, Caroline. Thank you, George. Before I turn it over to Ken, we do have a couple questions that I'll just throw at both of you. One is indemnification and insurance something that covers more than the installation, but is in place for future projects for the association, or future to protect the association, sorry. So does the indemnification provisions and insurance provisions of the bill extend beyond the installation?
It applies to any damage that would occur as a result of the installation and use of it. So yeah, it doesn't just cover the installation, but any of the potential negative effects of that installation. If there's electrical short or something, or a fire, yes, it would cover that.
But it's all directed, it all stems from the installation. That's what we're talking about right now.
By the way, John, I wanted to just throw out one of the takeaways that I'm hoping everybody's hearing is that rather than, and Caroline mentioned that there's that 60-day turnaround on an application, rather than spending a good part of that time putting together your procedure and putting your resolutions in place, I would recommend that those be done now, soon, so that everything is in place, so that when you get your application, all you have to do is review it, turn it right around so that you don't miss that 60-day window.
Okay. What sort of professional consultant does this sort of work developing specs and policies for EV charging? So we're talking about going to an engineer, correct?
Yeah, that's my understanding, is the engineer will develop the specifications for the type of a modification.
And then this one is probably a better question for an engineer than an attorney, but does this law apply to level 2 stations and or level 1 station?
The law does not differentiate.
Okay. Got one more question here. Does any of this apply to charging stations inside garages of fee simple homes? And if so, why?
The answer is yes. Again, just like any other installation, you're going to, especially when it's involving electricity and bringing it in from the outside, it's something that you have to submit an application to the association, even if you're doing it inside your garage.
Let me ask you this one more question.
And it applies to all common interest communities, not just condominium associations.
Right, and I think both of you addressed this, but let me just ask this so it's clear. Is the association responsible for the cost of bringing 220 power to the garage building so the owner can install a charger? Cost is prohibitive because new panels required. Garage is a cluster with assigned spots.
So if the association has to upgrade its electrical service as a result of an electric vehicle charging station, the law does allow any cost incurred to be passed to the owner or owners.
Great. Thanks to both of you again. And at this point, I am going to turn it over to Ken Sauter to talk about community association loans.
All righty. Thank you, John. All right. So the first question is, and I hear a lot of association boards are a little bit reluctant to borrow because it seems like an odd process to go through for an association, but it's become very, very common. So the question is, why borrow rather than just assess the owners? A lot of questions. One is a lot of issues to consider. One is authority. You may have certain hurdles to overcome if you need to get association membership approval to permit the assessment. So one of the first steps is looking at your governing documents or having your attorney look at your governing documents to see what avenues are available to the association. Is assessing versus borrowing, are they both viable options or are they not? Another reason is maybe there's insufficient reserves. By borrowing, there's an ability to sort of reserve your equity, meaning reserve your reserves, possibly for other projects. Timing. You may have a very large scale project that you'd like to get done now. I used to use the example before fuel prices go up, but that example is sort of out the window. But I guess we could say before they go up even more. there may be economies of scale of doing a project, sooner rather than later, one fell swoop rather than spreading it out. Your members may not want, their particular unit to be the last one in line. So by borrowing, it may afford the ability for an association to do the project more efficiently, more quickly, and then to just spread the costs out over time. There may be a legal requirement or an immediate need. We all know what happened down in Surfside. There are going to be greater impositions by various jurisdictions requiring associations to do projects more quickly. There's one example in New York City. They have a building facade law, so the bricks from the facade don't continue to fall on pedestrians. So they're under the gun to do those kinds of projects. A lot of associations don't have the reserves at the ready to do that kind of work. So borrowing is one method for obviously addressing those legal requirements. It does give you the ability to spread the costs out over time. Assessments are typically done over a number of years, 2, 3, 5 years, typically not much longer than that. By borrowing, it allows you to spread the costs over a longer period of time. Lenders routinely lend 5, 7, 10, even 15 years, and I've seen a few that are even longer than that. There are sometimes concerns from a marketing perspective regarding special assessments or assessments. So if you've got that sitting on the disclosure form from a seller to a buyer, it may have a marketing impact. By spreading the costs over time, the assessment number tends to bump up much less than if there's a special assessment or you're basically amortizing those costs over obviously a shorter period of time. There is no mortgage. The collateral for these kinds of loans is the income stream of the association, so that if there were to be a default, the lender can basically go and try to collect assessments directly. But there's no mortgage on a unit. It's not something that is required to be paid by a unit owner before they sell their unit. Between a seller and a buyer, the special assessment typically needs to be negotiated between a buyer and a seller. When you have a loan, those costs, those debt services, are simply part of your operating budget. My one word of advice on this page would be start the process early. It takes a long time. By the time you get around to putting together your documents and your submissions to the lender, getting whatever approvals are necessary, getting the loan commitment issued, through the bureaucracy of the lender, getting it closed, it is easily a number of months. So it's a process that if an association is considering approaching, do it much sooner than later. It's easier to slow down the process than it is to speed it up. Next slide. Pre-planning, just mentioned it. It is absolutely crucial. Try to get your attorney involved at the earliest stage. You need to make sure right out of the box that the association, the board, has the ability to borrow. You will find some circumstances where, because of the improvement cost, because of other issues and requirements and restrictions in the governing documents, it may not be a viable option. So have the conversation very early on with your attorney as to whether or not this is a path that the association is able to pursue. I will mention it later, but loan commitments, once issued by the lender, are negotiable. Make sure that you have those documents reviewed by counsel before it becomes essentially a contract. Mentioned a moment ago, there's an underwriting process. So early on, you'll probably have your property manager who will need to put together a whole bunch of documentation, financial statements, accounts receivable reports, delinquency reports, reserve studies, insurance, descriptions of any pending litigation. There's a whole host of information that needs to be gathered and submitted to the lender. So obviously, you're going to have property management involved from the very beginning. Typically, you'll have your property management company's controller involved from the very beginning, because they're the ones who are going to be looking at things like financial covenants and financial requirements under the loan commitment. As to authority and the ability to comply, as I mentioned, you really need to have your manager, your accountant, and the attorney involved very early on. Make sure they're all reviewing that loan commitment before it gets signed. I can't tell you how many times I have a client just say, oh, and by the way, we just signed this loan commitment. And then I look at it and I say, well, there are a whole bunch of things in here that were they considered by the board, the accountant, were they described? Are you able to even comply with all these conditions? And I'll mention a few of those examples later on. But please, 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 if you're going through this process, bring in the professionals as soon as possible. Next slide. So for example, typical covenants and loan conditions. And a covenant simply is just a requirement that the association is required to meet generally throughout the term of the loan. So for instance, the lender will be looking at your accounts receivable reports early on. They may also include conditions and requirements regarding delinquencies. There may be a limit on the dollar amount of delinquencies. There may be a limit on the number of units that can be delinquent beyond 30, 60, or 90 days. Those are things you need to consider before accepting a loan commitment. There may be requirements that you have balanced budgets. So you have to look at things like, are you using contingencies or sort of non-operating expenses to fund your operating budget? The lenders will likely look for it to be a fully funded budget. They will likely want the association to actually set up the debt service payments, the principal and interest payments on the loan, as a separate line item in the budget. There will typically be requirements that you submit your financial statements, which means you literally may be required to have your audited financial statements done within a specified period of time. I routinely see commitments that say that it will be provided within 90 days following year end. I would venture to guess that a lot of the audits are not completed within 90 days. So make sure you've got a loan commitment with a condition that you can actually comply with and will not result in a default or a request for some kind of variance from those conditions. There may be requirements for maintaining minimum capital reserves throughout the project. Make sure that the cash flow is going to work. And again, that's an accounting question that really needs to be reviewed by the association's accounting personnel. There may be requirements for compensating balances. We're actually maintaining reserve accounts or some other quasi savings account with the lender. There may be requirements that the lender actually review and approve the construction contracts. There will be likely requirements on a construction type of loan, and that's typically what we're talking about, that obviously you get all permits and approvals. There may be requirements that you have an engineer or an architect who's involved in the process from the beginning and is basically confirming to the lender that as money is advanced under these loans, it's based on work that has been completed and has been completed satisfactorily. Most of these loans will not release the entire amount of the loan at the outset. They'll be staged and released over the course of the completion of the work, again, based upon inspections and statements or certifications by your architect or your engineer confirming that the work has been completed. You'll sometimes find limits or conditions in the loan commitment on the number of rented units. You may routinely find that there are limits on other financing. Once you've got one loan with one lender, they're not going to want the association to be borrowing from others. If you have an outstanding loan for your association, that loan will likely need to be paid off if you're taking on a new loan. So, I mean, this is just a sample of the kinds of terms, conditions, covenants, restrictions that you're going to see in many of the loan commitments. You need to see these, know these, and understand the impact from the very outset. And there's no reason why a lender can't give this information to you fairly early on. Most of the loan commitments are pretty stock documents. They will fill in the rates and the basic business terms at the time of underwriting. But there's no reason why you can't request this kind of information up front to understand what you're going to be required to comply with. The next slide, thanks. Again, the attorney's role is to basically give you information regarding whether this can actually proceed and to make sure that you're not going to be wasting time and hitting roadblocks that are not anticipated. I'm not going to go through all the slides because they tend to just give a little bit more detail on what I already mentioned before. But clearly your loan documents will have provisions such as what's the rate, and rates can be either fixed or adjustable. You will see a lot of loans that do something like they will have a 1 or 2 year construction period where you're just paying interest. And then once the construction is completed and you've advanced all of the loan or most of the loan and you're done with advances, they will then typically convert it into a fixed term for the balance of the term. So you might have a 1 or 2 year sort of line of credit construction period, and then it would convert into a fixed loan for the balance of whatever the term is. That's very common. If you can slip forward to maybe 2 more slides. Next one. One more. All right, so loan terms I mentioned before, 15 years, not uncommon. Be careful of balloon payments. If you have a loan that's amortizing over 15, 20, 30 years, but it's due in 5 or 7, that's something you need to understand. Be wary of the prepayment provisions. Most lenders will lend you money and they don't want you going out and then shopping that loan to somebody else if the rates go down over the next year or 2. They want to know that the time that they've invested in lending to the association is not going to be for naught if the rates go down, although we can only wish that that happens. Concerns about rates, I mean, it's no different than when you took out a mortgage loan on your individual unit or your home. Do you want it to be fixed? Do you want it to be floating? The rates obviously are going to differ depending on those two. Nobody has a crystal ball, so nobody can tell you what's going to happen with rates. I'm old enough to remember fixed rates being 12 or 13%. So when I see rates going up to 5%, it doesn't startle me as much as it may some, but you can expect rates to obviously start to tick up. So that is basically loan commitments in a nutshell. Again, I'll say it the 3rd or 4th time, make sure that as a board, as a manager, you're discussing this with the association's accountant and with counsel as early on in the process as possible. Thank you.
Great, thank you, Ken. I don't see any questions at this time. So what I am going to do is turn it over to Michael Karpov, talk about capital improvements, and then we should have a couple minutes at the end to answer some questions, whether it's about these presentation topics or other questions you may have. So with that being said, Michael, take it away.
Thank you, John, and good afternoon, everybody. I normally like to start off a talk that I give with a joke to loosen up the audience a little bit, but when you're doing a webinar and there's no feedback or laughter from the audience, it makes the joke kind of a dud. So I would ask that each of you pretend that I told you a joke and take a few seconds to laugh. What I'm going to talk about, though, is really no joke to board members and to managers, and that's capital improvements and major expenditures. Initially, we need to note that there is an inherent conflict of interest between the board's duty to maintain common elements versus restrictions on expenditures. The board has a fiduciary duty to maintain and repair the common elements, but frequently there's a restriction in the governing documents on how much they can spend or whether they can spend any money without a vote of the owners. And I think we all realize that generally owners do not like to spend more money than they have to. So seeking a vote from the owners can be a difficult process. The first thing to do is look at the types of restrictions that apply to your community. And they are either in the master deed, the declaration, or the bylaws. And I think there are generally 3 classes of restrictions that may apply. One is for a board to spend over a certain amount of money that has not been included in the annual budget. For example, $5,000, or an amount that's listed in the original master deed and then increases annually according to the consumer price index. Another kind of restriction that we generally see is specially assessing owners over a certain amount to raise funds quickly. And a third general restriction we see are for capital improvements costing over a specified amount. And I'm going to focus on capital improvements in this talk today. Can we have the next slide, please? All right, so the first question is whether something is a capital improvement or merely a repair or replacement. If you're fixing something that's broken, that's a repair. For example, if you have damaged siding and you're just replacing the damaged siding or patching it, whatever you're doing, that's a repair. Generally, you don't need approval of the owners to do a repair. That's usually in your operating budget. If you're replacing something that's worn out, that's a replacement. For example, if the roof has reached its expected lifetime and you're replacing the roof with similar materials. But if you add something new, that's a capital improvement. For example, if you decide to add a tennis court, or if you decide to eliminate a tennis court and install, for example, a pickleball court instead, that might be deemed a capital improvement. And there's also some cases where changing the style of the roof, the roof has reached its end of its lifetime, you need to replace it, but you want to upgrade it and change it, say, from shingles to tiles, that could be deemed an improvement, and that could be deemed a capital improvement that requires approval. The best thing to do is, if you're in doubt at all, consult with your attorney and ask for advice as to whether something is a capital improvement or a repair or replacement. Now, the next question is, depending on what you determine the item is, do you need owner approval? And as I said, you can look at your governing documents to see what's required. If the item is included in your capital reserve fund, you generally don't need owner approval because it's already been budgeted for. But as I think Ken mentioned, if the cost is going to exceed the amount that's in the reserve fund, then you may need owner approval. If you exceed your spending limit or your assessment limit, you may need owner approval, depending on the language in your documents. Now, you might be able to avoid that by consider taking a loan. As Ken mentioned, you can amortize the loan over a number of years, and then you include the owner payments in your regular budgets each year. But many associations, for whatever reason, decide it's better to specially assess for a limited period of time than to take a long-term loan, and therefore they seek to raise funds immediately. Now, if you're in doubt as to whether you need owner approval, you certainly can seek owner approval, and we recommend that in many cases. Seek owner approval, explain to the owners that you don't think you need owner approval, but you want to gain owner support for this major project, and you want to avoid future potential challenges, particularly court challenges, that may sidetrack the project. So you're seeking owner approval. And the reason why you can use that explanation, why it's helpful to you, is because if you don't get owner approval, you may be able to argue that you did not need it in the first place. Next slide, please. So how do you get owner approval? This is a process of education and communication for the owners. And depending on the size of the project and the extent and the size of your community, it may be a very lengthy process to fully educate the owners. You should have meetings with the owners. You should be sending letters to the owners explaining what's going on. Give the owners copies of the experts' reports, the professionals' reports, to explain to them what needs to be done and why. At your meetings, take questions and answer them. You may need to have small group meetings. It's difficult if you have a very large community to have a meeting with 100, well, hundreds or 1,000 or more people. So it may be necessary to have small group meetings. And it may also be necessary to go door to door to educate your owners as to why this project is necessary and why they should approve it. And above all, include your professionals in this process. Even if you have more than one meeting to explain what's going on, include your professionals so they can talk about why this is needed and what's going to happen. And by professionals, I include your engineer, your accountant to talk about the financing, and your contractors to explain what's going to happen and what the timing is going to be. And the last question is, what do you do if the owners don't approve it? Well, one thing is to consider other options. You may be able to consider different kinds of financing issues and options to make the expenditure more amenable to your owners. You may be able to phase in the project so that it's not as costly in a lump sum, and the cost can be phased out over time. Or, I mean, as a board, if you've done all you can to try to get the approval and you can't get the approval, you may not be able to do anything else. You may just have to give in to that. But as I said, if you've explained that this doesn't really require unit owner approval, you may still be able to go ahead and do the work without the unit owner approval. The last resort, and I've listed it on the slide, is litigation. As a last resort, if the work must be done and you cannot get the necessary approval from the owners, you can file a lawsuit asking a court to order that the association do the work. And we have had to do that in 2 or 3 cases where it was just necessary to get this work done, raise the funds from the owners. We named all the owners as defendants in the lawsuit, asked the court to order the work to be done. And generally, there's little or no opposition to that from the owners, because when you get to that level, most owners realize the work needs to be done and they need to pay for it. That's all I have. Back to you, John.
Thank you, Michael. We do have 2 questions. First question is, whose responsibility is it to have ample funding in a reserve account with or without a reserve study?
The responsibility belongs to the board. You know, the key question is what's an ample amount in the reserve fund? There's little guidance as to how much you need to reserve. And therefore it's helpful to have a reserve study, because then you're getting a professional recommendation as to what should be reserved. And therefore I recommend to my clients that they have periodic reserve studies. And I think the failure to have a reserve study may not be appropriate performance of duties by boards.
John, I can add in too, John, that most governing documents will have that requirement in there that, as Michael said, it's the board's responsibility to ensure that that reserve account is there. It doesn't give a whole lot of guidance, but it's there. But I can tell you there is currently no statutory obligation for those reserve accounts, although that is likely going to change in the coming months because the legislature in Trenton is now working on legislation that would not only require periodic testing and inspections of your buildings, but also will require a certain level of funding be made available so that there will be enough money to make repairs when those repairs are needed, so that we can avoid the tragedies like we had down in Surfside, Florida.
So next question, which has to do with similar question, but whose responsibility for have ample funding with regard to deferred maintenance?
I'm sorry, with regard to what?
Deferred maintenance rather than reserves.
It's the same answer, except that I think there's less standard on how much is needed for deferred maintenance. But again, the board is responsible for creating a budget, a reasonable budget that can fund the needs of the association. and the board members should be using their professionals to make recommendations as to what is needed. Now, it doesn't mean a board has to strictly follow a recommendation by a professional. But if they're not going to follow that, they ought to have a good reason to explain why not. But that's the best protection for the board and the association, is to use your professionals, get advice from them, and then follow that advice as long as you can.
Right. And then the follow-up to that was, so in essence, the board can increase the balance in the reserve account via funding plan without going to the owners. And Michael, I think you answered that, if it's budgeted, based on a capital reserve study or something else, obviously, yes. But if they're looking to do that special assessment, it may depend on what their documents are and what they want to use that money for. Is that correct?
That's correct. Mm-hmm.
Excellent. So we do have a couple minutes left. If anybody has any questions about what we talked about today, or any questions at all regarding your association, please feel free to type them in the Q&A now, and we'll be able to answer them. So I'll give everybody a minute if they do have any other questions, whether they're about what we talked about today or whether they're something unrelated.
John, I just wanted to follow up on something that Michael said. It may not be that popular or known, but there's also the ability to fund litigation costs through bank loans. I've seen many of those. So if you have an association that's in transition, doesn't have the funds to fix and or to cover its transition legal costs, that's also a possible avenue with respect to many lenders.
Okay, I don't see any other questions. So anybody have any closing thoughts before we wrap this up?
John, I saw a question from Kimberly asking, can an association put in an electric vehicle charging station and make money from it? That's an interesting concept, right? The new law that was just signed in January says that the association, yes, can put in their own common area station. And the law says that they can only be charged the residential rate, but it also says that an association can charge its owners who are going to use this common electric station anything that they want. So it may very well be that an association charges extra for the electricity to help pay for the installation of the machine in the first place.
Yeah, but George, I guess the one issue is that in charging an owner for whatever costs are incurred, there's an overriding policy that the association cannot make a profit in those cases. And there's another issue, and I'm not an accountant, so I don't really know how it affects, but the other issue is if you start making a profit off of these charges, how does that affect your tax status? And that's something you should talk to your accountant about.
You absolutely should, but Michael, I think I mentioned that if it costs the association several $1,000s to install the machine, it would seem that by charging extra for the electricity could be seen as a way of paying back or reimbursing the association for that initial expense.
Right, but it's not merely a profit center. That's my point. You can't just charge every unit owner who installs an electric charging station. I don't think you can. A lump sum that you use as a profit center for the association.
Right.
One more question, which I'm going to give to Ken. If applying for a bank loan for a project, does that go to the owners? I assume that means for a vote of the owners.
The answer is it depends. It's really more dependent on some of the things Michael talked about. How is the money being used? If there's no special assessment involved, then you take that out of the equation. If you have some documents that will say you can't spend more than X dollars on improvements or reconstruction, so you've got to look at those provisions. And then there are maybe separate restrictions on the right to borrow or not to borrow. So there are different questions: the right to borrow, the right to assess, and the right to actually spend money on improvements costing more than X dollars. All the more reason to get the accountants and the attorneys involved very early on.
And then one more back from, I'll give this back to Caroline or George, which ties in with Michael's topic. So if we are putting in a common charging station on common ground, wouldn't that be a capital improvement?
Probably so. If it wasn't there before and you're adding it, it would be a capital improvement.
Funny how all of this ties together.
Well, there actually was some connection among all our topics. See?
So I want to thank all our presenters for today. So thank you, Michael. Thank you, Caroline, Ken, and George. If you do want to contact any of our presenters, that information is on the screen right now. We are taking the month of June off for the webinar, but we will be back in July for another Power Hour. And if you do have any other additional questions, if you do have any topics you'd like to hear us discuss, actually the electric vehicle charging station topic was one suggested by one of our viewers. So please email the info@Hill-Wallach. And again, thanks for everybody for participating today. Thanks for everybody for joining us. And we'll see you in July. Thanks.